Welcome to Chasing a Murder, and guys, you don't want to miss this morning.
Good morning, Your Honor. Pamela Hicks and Robert Abernathy as advisory counsel for Miss Daybell.
Go ahead and announce.
Lori Daybell.
All right, thank you. My courtroom assistant said there's some issue with advisory counsel at the table.
Yeah, I apologize, Your Honor. I didn't think about the logistics, so I'll just let Miss Daybell.
Okay.
Yeah, I was going to ask if I could have my investigator up here at the table, because if I needed to ask him something, then I need him available.
Yeah, any side can designate an investigator to sit with them through the trial and through court proceedings.
Good morning, guys, and Lori Vallow is at her pretrial hearing for Charles Vallow for allegedly conspiring to kill her husband. They believe that the responsible party that actually shot Charles was her brother Alex Cox, who is now deceased. If you don't know the story, go check out my series, Life Beyond the Grave. It is incredibly detailed. This story is one big rabbit hole. It just never ends. So Lori started out with this trial wanting to bring up her whole team to her defense table. You got to remember that right now, according to Lori, she's in a 23-hour lockdown. She's wanting to represent herself, be her own defense attorney, which is going to make things incredibly difficult. She refused to waive her right to a speedy trial, and this will become an issue several times during this hearing. We will go over that shortly. She's not just facing charges or conspiracy charges for Charles Vallow, but also the attempted murder of Brandon Boudreaux, her nephew-in-law. So 2 trials. The best thing she can do is just not be her own attorney, get an attorney, and maybe even make a plea deal. It's not like it really matters since she is convicted for the murder of her 2 children and Tammy Daybell. They could just screw up this entire trial. It wouldn't make a difference for her. But for Lori, it's about gaining her way, winning and manipulating the system and making people believe the false narratives. That's my opinion based on my research of Lori. And what's weird is she truly believes that she has a chance to win here. Now, in past, if you remember, Lori actually was facing death row until prosecutors made a boo-boo. But in this case, she'll miss deadlines and seems to just get a slap on the hand. To many people following this case, all the money going out, taxpayers, dollars, to this game she wants to play that she won't take seriously. We have elderly that can't even afford medicine, but we have this person that's already been convicted of killing her own children getting millions of dollars for her court cost. She has an advisory team and not even pay a penny. Now we're going to listen to some of this hearing. I'm not going to cut out a lot of it, but you're going to notice that she's pushing for her speedy trial and not pushing for a speedy trial. And the purpose of this, I feel, is just her to try to manipulate or cause issues. She doesn't even have to win. She just wants to find a reason to point the finger at them. Lori loves to be right. She loves to lead and be the person that is most knowledgeable and basically just get her way. Most of all, she enjoys making people's lives miserable. Way different from the mom that likes to make things a lot of fun. She paints it one way and does it another.
If you can fit 3 chairs there, that's fine. Otherwise, advisory counsel could scoot her chair behind, whatever you think is logistically easier.
Appreciate it. Thank you, Your Honor.
All right. Have the parties, I had my staff drop off the proposed questionnaire on your table this morning. I know you just got it this morning. You may need some time to read through it. That's my proposed questionnaire. Obviously, there's maybe a lot more questions that either side would like to ask the potential jurors in follow-up. So this is not limiting what would be asked ultimately to the jurors. In addition to this, the questions in this questionnaire, when the potential jurors come in, I always go over the burden of proof. I go over credibility of witnesses in a little more detail, especially as it pertains to how people perceive officer testimony, and some other areas I'll highlight. So I intend on asking more than just what's in this questionnaire, but this questionnaire is intended to get through some of the bigger issues such as pretrial publicity or opinions people may have had or exposure to the case people may have had, and then it has the questions where we may lose additional jurors on the trial schedule, and then victims of crime, views about police officer, and then if they've been charged or a close family member's been charged with a criminal offense, and to explain that. Any comments from the state?
Judge, in terms of publicity, I think my concern would be that when the jurors come in here and start hearing about the case or hearing testimony about the case, they'll hear the names Tylee and JJ, which obviously were more, there was more publicity about those than about Charles Vallow. And so I think if we really want to ensure that the jury is unbiased and has had no pretrial publicity with regards to the defendant, we're going to have to question them as to their knowledge of her other convictions out of Idaho. That was something that was just incredibly all over the media.
I agree, but I think that may happen in individual voir dire. This initial questionnaire, if they recognize the name Vallow or Daybell and they've been exposed to something in the media about it, they should tell us about what they know about it and about whether they know about that other case and whether they know about anything that happened to it about it. So I anticipate losing a number of jurors just based on that. But I agree with you.
All right. Well, believe it or not, guys, there are people out there that do not know about this case. But because it happened in Arizona and Idaho, it's going to be a little bit more difficult for them to choose a jury, but it's going to be almost impossible not to at least have a few people on the jury that know a little bit about this case. It's not until recently that Lori really kind of come to terms of how this story has captivated the nation. And she's really kind of starting to understand the gravity of it, but at the same time doesn't understand the gravity of how much trouble she's in and how what she did was evil or wrong. Basically, the judge will say, there will be people there, but will it affect their ability to be fair? If you were on the jury for this case, could you be fair?
Some may say they've been exposed to it, but it wouldn't affect their ability to be fair. And in individual voir dire, we can explore those options. I don't want to necessarily taint the whole pool by saying, hey, she's got these convictions in this other state.
So the fact that 2 children are dead, that's going to be a huge problem for anyone that followed this case. The state has a good point. JJ and Tylee and Tammy were well known as one of the most horrendous crimes of 2019. Charles Vallow's case, well, it's not as known. So really the problem is it's not Charles Vallow's case, but the case that was trialed in Idaho.
And Your Honor, I don't propose we will hear the names JJ and Tylee in this trial. So that's my concern, is if we don't raise those names, whether or not we put them in the list as people that they may hear.
What I could do is there any in addition to those 2?
That would be the only for that. I think the other issue is, of course, the defendant's supplemental 15.2 names.
When was that filed? I haven't seen it.
I filed actually 2 motions to preclude them all and emailed them to your court.
It seems that we're not the only ones that's very unhappy with Lori Vallow's witness choices. Seems like the prosecutor, Treena Kay, is also not happy with her choices of witnesses and believes that there's a few problems, like calling a reporter to be a witness in the case. Reporter Nate Eaton, who has been threatened to be by Lori's team to be a witness for the defense multiple times. So it seems that they're going to try to preclude a few of them.
Sunday.
Okay, maybe that's in my folder that's on my desk. Before we...
Defense filed that on the 12th of March.
Okay, before we get to that, let me ask the defendant. Other comments on the proposed questionnaire and the information that we're going to put in there?
I think this is the first time I've ever seen Lori kind of speechless and not sure what to say or do. That was interesting to me, but just watch how she kind of handles this.
I think it's
What's that?
pretty clear.
Okay, do you have any objection to listing Tylee and JJ because they will be mentioned?
No?
Okay.
So what prosecutor was trying to say is that just a mention of Tylee and JJ's name could be very damaging to her. But Lori Vallow doesn't see it that way. She sees it as an opportunity, most likely, in my opinion, to manipulate the situation and to make her look like a good mother. That's the way she's done it for years. A very uncomfortable moment happens right here. She'll look at her advisor, who appears to be not too comfortable during that moment, and Lori seems very embarrassed.
Let's take a look.
And uncertain.
Let me ask the state, you have 21 witnesses listed. I need to look at the defense witnesses that were listed. And
So now we're actually hearing there may be 21 witnesses listed for the state. And then, of course, we have seen Lori's crazy witness list. She has even listed Brandon Boudreaux, who is the next trial to happen after Charles Vallow, the guy that they attempted to shoot on his way home. How could he possibly be a witness for her and Charles? Honestly, you have to ask yourself, what's her true intentions with listing Brandon Boudreaux as a witness? What's interesting about this hearing is if you can watch the prosecutor and Lori, well, they have some, looks that they throw at each other. And you can see where Lori's starting to get intimidated. It's like watching a beauty school dropout versus a college female attorney. I can see it now. Lori, as the defense attorney, asking Brandon Boudreaux, weren't we good to you? Were we a good, close family? Brandon's response, yes. Until that time I was shot at.
set forth, but from April 7th to May 15th, the current screening, that is 20 full days of trial and 2 half days, so essentially 21 days of trial. Do you really think we need to screen that far out? I know you're being overly cautious.
I think, especially given that I'm not positive we'll pick a jury in that first week, I think we should, Your Honor.
Now, it's very clear that the prosecuting attorney here wants to dot her I's and cross her T's and make sure there's no mistakes, no room for any type of problem, and to bring justice for the families. The fact that she's that aware of who Lori is, well, I'm going to be very interested in watching her work.
All right. Defense have any comment on how we're screened through May 15th?
I think it's plenty of time, Your Honor, myself.
All right, let's deal with a couple things. First, I've received the notice of compliance. That was when the defendant requested the Gilbert video. Does that apply to the second case? or this case?
Your Honor, it's
So now they're talking about camera footage that was from the ceiling when Lori did an interview with Gilbert. I think it's the Gilbert police. It's whenever Charles took her purse, I believe. No matter what, what Lori's wanting to do is go through footage, hoping to find something someone looked over, whether it would be helpful or not helpful. She's very determined in that way.
an incident that occurred in January. It's not really, it was disclosed because it is mentioned in the DR. The defense had filed a motion for the state to disclose that, and then had brought up again on the 11th that the state had not disclosed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that police report that is peripherally relevant.
All right. Any comment on that?
Yes, Your Honor. For clarity, is the state proposing that there is no video or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator or someone told you about it.
A mitigator.
A mitigator.
Showed it to me.
If they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already...
Let's pause here because she has a concern. She's about to go over that her former team in Idaho would not release records or documents to her. A lot of people were angry with these two attorneys, but I would love to hear what they actually went through representing Lori, because they went through a lot and she was very demanding, and I would like to know what they had to fight with her on. It's interesting that she's claiming that they will not send her any of the information she needs, disputing there's some type of conflict.
already disclosed.
I will tell you why they won't, because that is my former team, and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
All right. Do you know, and maybe your advisory councils can speak to this, did they turn over a file to you, or did you have to start from scratch?
No. From what I understand, all they turned over was the 22 terabyte hard drive, and that is it. They didn't turn any notes, any work product, nothing that they had done to that point.
Lori claims this includes some of the stuff that she gathered and got for her defense team.
And they continue to stand by that today, even though a lot of that information I gave to them, they would not give it back to me.
I make an order, and it'll be in the minute entry that they turn over a copy of their entire file, including any mitigation information that was gathered, to the advisory council. To makes Hicks, you look like you want to say something.
I don't know.
Right.
No, I'm good, Your Honor. Thank you.
All right, so I'll do a more detailed order about, they should have turned over a copy of their entire file to advisory council when they withdrew.
So there's something more going on with the defense there. I don't know what's going on, but going back to the fact that Lori claims that her previous defense team wouldn't release everything, citing, there's a conflict. We don't see that in documents. We didn't hear that from them directly. So we can only assume that she's telling the truth, which is very rare. So maybe it has something to do with a personal interest. Is there some kind of third party interest? Attorney conflict? Do they have a client that they're representing today that might be somehow attached to Lori? Are they doing some type of documentary, maybe a book? Maybe they're trying to prevent some kind of disqualification with the attorney she has right now. Perhaps Lori had made a complaint about her attorneys. There's a few things it could be, if it's true. And dealing with Lori Vallow, you can bet that if Lori feels like she's been tarnished or her reputation tarnished, or she just gets mad at someone, sometimes she tries to make their life difficult. And you have to wonder, it might be a couple, if you think about it. It could be personal interests, and then, of course, having to deal with the legal parts of dealing with Lori. Lori is her worst nightmare, her own worst enemy. And she's great at burning bridges. Real quick before I forget, so they plan on a start date for one of the trials. March 31st for Charles Vallow and May 30th for Brandon Boudreaux. So I was looking at this Robert guy that is the investigator for Lori's team, and he seems to be tired. Well, let's listen to what the prosecutor said about getting an email late one night.
At like 10:30 at night, defense investigator emailed the state and indicated that the defense expert would need to or wanted to obtain the physical laptops and cell phones that the police had impounded so that he could then review them, do his own sub-right or extractions. So obviously the expert hasn't even begun work, let alone they've also requested all impounded items from law enforcement. I'm unclear if they're asking for ones that were impounded in Idaho as part of their investigation or just the ones here. The statements from the investigator appears to be all of them, which would mean the state would have to request Idaho to send those to the investigator. So again, given all of those issues, I don't see how that it would be possible for the state to provide that to the expert prior to this trial beginning, let alone to get a report or an opinion prior to this trial beginning.
So here you are, just a few weeks from trial, and the prosecutors got major concerns about Lori's ability to be prepared and what she's doing to defend herself. She really doesn't feel, and you can tell that Lori is prepared for trial, and she just doesn't know what to do about it. Not only that, she's throwing extra unnecessary work onto the prosecutor, who is the good guy in this case. She's having to work this very stressful environment in order to try to bring justice for Kay and her family.
All right, let's set aside Dworkin for the time being. So well, let me ask the investigator. What's your name, sir?
Jeff.
Jeff what?
White.
Okay, Mr. White, are you going to be setting up interviews for the state to interview whatever potential witnesses the defendants noticed?
I'm trying to verify, excuse me, sir. I'm trying to verify the phone numbers to be correct. I do have a few of them, but some of them I'm trying to make sure that this is the correct numbers.
Okay.
I did the searches for them, and I have to apologize. I left yesterday, and for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list, with the exception of one,
Which is who?
which is Nate Eaton.
Okay.
And
When you say the state's done the interview, do you mean police or someone from the prosecutor's office?
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Okay.
So I know that they had their addresses. I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone. I don't have...
Firstly, are they giving her a cell phone in her cell? I know that they do have monitored phone systems for making calls, but this sounds like she's talking about batteries. Wi-Fi. What's going on here? Not only that, she knew that representing herself would come with these complications.
have access to get to people. So I understand the time constraints, and we're doing the best that we can of getting things answered, getting things put together.
So as a threshold question, your assertion is that all these people that you've listed in your notices have relevant information for trial?
Correct.
And do you know if the police have interviewed these people?
Your Honor, the
They may be
first
referenced.
listed person is a reporter. So I'm not really sure the relevance of a reporter.
He's the only one that hasn't been. So that's what I stated.
And then the reporter's name comes up again as a witness, which doesn't make sense. It doesn't fit. And it just seems like a way to create an issue with Lori.
So, Your Honor, the point is to start with, one, these people, I'm not sure all of them actually have been interviewed. Those that have would have been interviewed 5 years ago. So whether or not their addresses are correct, unclear. It's not the state's responsibility for the defendant to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does.
So here you can hear the frustration of the prosecuting attorney, and you can't blame her. She has her own work to do. And here Lori is throwing all this unnecessary burden upon her. Drop in the comments. What do you think? Is Lori unprepared on purpose, or is she just that dumbfounded? So a lot of Lori's witnesses is character witnesses, and she's not a fan of that either. So the majority of Lori's witnesses is there to tell what either a great person she is or a great mom, in quotes, great wife she is. All right, guys, I'm going to leave some of this playing. If you want to watch it, you can continue watching. Just please push like, subscribe, share. That would be appreciated. And also, don't forget to say hello in the comments and share some of our missing girls on your social media today.
In terms of the witnesses, I think that most of them, as best I can guess, would be character evidence, which would be improper under 405. So depending on what they say, then I need to file motions to preclude or motions in limine for any or all of these witnesses.
All right, so it's premature to address these today. The state's going to have to interview them and find out if, in their opinion, they have relevant information or not. And then if there's a dispute as to whether or not they'd be called, I'll have to deal with that as it comes up. But if they're unable to be located or interviewed, obviously they won't be called at trial. Mr. Dworkin, if you want him to do extractions, you're not ready for trial. So in order for him to do the work that he's requesting, getting copies of a laptop or a cell phone or whatever the case may be, that's going to take him time to extract and analyze and then prepare a report. Months, maybe.
I understand that, Your Honor, and I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th
Well,
from OPDS.
you're the one pressing for your speedy trial, so you kind of have to make a decision on, we're set for trial. You want to go to trial or you want to have him do that work that you want? Because I don't think both are going to happen. Even if he got the laptops today, generally those types of things can take weeks, even months to analyze and prepare a report on.
I understand that, and I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting them ready, then he can give us a report with the best that he can do.
Well, the report's already late technically, but if it were allowed, first of all, it's going to take time to coordinate him getting the. Let's start here. Specifically, what are you requesting? Because the state wasn't clear whether you were requesting items here impounded by a particular police department or items that may be impounded in Idaho.
Well, I'm sure that my investigator would like to have all of those things done, and I realize that we're on a time constraint, and I would be only concerned with one item, which is at Chandler Police Department, which was Charles, my husband's phone. Charles Vallow's phone.
Ask for a copy of the extraction.
And I would like a copy of the extraction that they took from it. The digital forensic extraction from Chandler Police could be given to him immediately. That would be very helpful.
Wasn't that already disclosed?
Yes, Your Honor.
Was that part of the initial terabyte?
Yes.
Excuse me.
Yeah.
Everything that I have is on a 22 terabyte. So if hard drive. So if I give that away, I can't do my work.
Well, can't you make copies of files out of it?
22 terabytes.
I understand that.
Okay.
So what's your proposal?
I'll take it up.
I mean, if you have all that information in a file, I'm not saying you have to copy the whole 22 terabytes, but there's a file in there somewhere that's the Cellbrite extraction already for that requested item that's been in defense possession for however long now.
I'll take it up to Lonnie.
So I'm happy to make an order, but again, if he's not done with that information you want, are you still wanting to proceed to trial at the end of this month?
Yes, Your Honor.
Okay.
Your Honor, I would ask leave that depending on what Mr. Dorkin says, that
Well,
would
it
put
could
this.
still be precluded because depending on what his opinion is, first of all, it's late under the rules of evidence and rules of disclosure. And secondly, depending on what he says, the state would have to have an opportunity to consult with an expert as well. So even if he got something done, it could still be precluded, but I'll give him the opportunity to do whatever it is that you think he needs to do to analyze that. But that information's been in defense possession for months, if not over a year.
More than a year, Your Honor.
Yeah.
And he was just approved by OPDS last week, Your Honor.
I thought you said he was approved. You applied in January.
I applied for him in January, and last Friday, he got approved.
Again, this is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense do the work that you want done on your defense. But if you're telling me you don't want to do that,
I would like to do that, but my situation in my housing department precludes me from doing that.
from asking for a continuance?
No, from getting things done in an effective and quick manner.
Okay. All right, well, so you're telling me you don't want a continuance because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
Okay. So I guess I'm going to have to cross the bridge on whether these notice defense witnesses are even able to be located and interviewed before I make a decision on whether they have relevant information and can be called at trial.
Obviously, Honor, we have a little over a week to try to interview these people, so I will
understand.
file something at the end of next week indicating who I've been able to reach and interview and ask to preclude everyone else.
All right.
They also obviously ask to preclude them regardless,
Right.
based upon what they may say.
All right. What else do we need to address today then?
Your Honor, the only other motion that we did not address last week was the state 609 motion. I presume the defendant will likely testify, so I didn't know if we wanted to address that now.
Are you prepared to address that now?
No.
I generally will, I guess I'll advise the defendant now that if you choose to testify, it's likely that the jury would hear about the convictions. But at your request, they could be sanitized, meaning that they would only hear about the fact that you have convictions, as opposed to what the nature of the conviction are. But that would be up to you, whether you want that information out or not. And then the jury would receive a limiting instruction that the existence of those convictions is only to be used for the purposes of determining credibility. So you should be aware of that when you make a decision on whether you want to testify or not. Oh, if you do want to testify, it will be question and answer, meaning you need to write out all your questions that you want to be asked and have one of your advisory counsels ask those questions to you when you're on the witness stand.